The honourable member for Scarborough Rouge River.
Thank you, Mr. Speaker. I will be sharing my time with the member for Beaches East York. Mr. Speaker, I rise today to add my strongest objection to the bill at hand, Bill C-31, the Protecting Canada's Immigration System Act. I find it ironic that this bill be given this title, as it will do anything but protect our immigration system. In fact, this bill sets out to dismantle our immigration system, damaging it legally, socially, morally, and internationally. I find the omnibus nature of this bill very disturbing. This particular bill groups together two major pieces of legislation: Bill C-4, the Preventing Human Smugglers from Abusing Canada's Immigration System Act, and C-11 from the last Parliament, which is the Balanced Refugee Reform Act. And then it goes on and introduces the mandatory collection of biometrics for temporary residents. These are three major issues, and all deserve adequate attention and debate. I've already stood in this House and expressed my strong objection to C-4, yet components of this bill reappear here in C-31. Namely, in this bill, the fact that this bill attacks refugees rather than human smugglers. By placing an overwhelming amount of power in the hands of the minister, this bill will allow the minister to designate a group of refugees as an irregular arrival. If he believes that examinations for establishing identity, for example, can't be conducted in a timely manner, or if it's suspected that the people are being smuggled for profit, or a criminal organization or a terrorist group is involved in the smuggling. Designated claimants are then subjected to a number of rules. They will be mandatorily detained on arrival or on designation by the minister, with no review by the Immigration and Refugee Board for their detention for a year. Release is only possible if they're found to be a true refugee. If the Immigration and Refugee Board orders their release within a year, even then the Immigration and Refugee Board can't release the person if the government says that the person's identity hasn't been established, or if the minister decides that there are exceptional circumstances. Decisions on claims by designated persons cannot be appealed to the Refugee Appeal Division. Designated persons can't make humanitarian and compassionate applications. A designated claimant can't apply for permanent residence for 5 years, Mr. Speaker. If the person fails to comply with the conditions or reporting requirements, that 5 years suspension can be extended to 6 years. This raises a number of concerns. Firstly, this is extremely discriminatory, as it creates two classes of refugee claimants: a real refugee and a designated claimant. This is possibly a violation of the Canadian Charter of Human Rights and Freedoms, equality rights, as well as the Refugee Convention, which prohibits states from imposing penalties on refugees for illegal entry or presence. Secondly, detention without review is a clear violation of the Charter rights. The Supreme Court already struck down mandatory detention without review on the security certificates. This legislation will imply indefinite detention on the basis of identity, with no possibility of release until the minister decides that identity is established. Arbitrary detention is also a violation of a number of international treaties. Thirdly, designated persons would have no access to the Refugee Appeal Division. This means that these claimants would not have the right to an appeal, thereby removing any system of checks and balances. Additionally, Mr. Speaker, the mandatory 5-year delay in applying for permanent residency will further delay the family reunification process, forcing claimants to wait 8 to 10 years to be reunified with their spouse or child living overseas. Lastly, this legislation creates an undue barrier for humanitarian and compassionate claims. Mr. Speaker, I am extremely concerned with the idea that the minister can name someone a designated claimant based on irregular arrival, with no explanation of what constitutes an irregular arrival. If we look at the history of the legislation of this nature introduced by this government, we can see that it has glaring resemblances to Bill C-49 in the last Parliament. C-49 was hastily drafted by the government when Canadians witnessed the spectre of boats coming to the shores of British Columbia, carrying some of the most damaged and wounded people on Earth, fleeing, as the minister has rightly pointed out, one of the worst civil wars in the world in Sri Lanka. Never ones to pass off a good photo op, the Minister of Immigration and the Minister of Public Safety were in British Columbia holding news conferences where they publicly accused the people on these boats as being bogus refugees, harboring terrorists and trying to jump the immigration queues, queue jumpers as they called them. I find this extremely confusing, Mr. Speaker. This government seems to be speaking out of both sides of their mouth. On one hand, you have the Minister of Foreign Affairs referring to the Sri Lankan Civil War as one of great atrocity, where numerous war crimes and crimes against humanity were committed. And on the other hand, you have the Minister of Immigration and the Minister of Public Safety accusing people fleeing this very violence of being bogus. This is completely absurd. Which one is it? Some of the refugee claimants and the refugees who arrived on the MV Sun now live in my riding of Scarborough Rouge River. Many of them have told me stories of their trip to Canada and their arrival in British Columbia. Many of them had UNHCR refugee cards. Upon their arrival, the people who greeted them gathered all of their refugee cards, and then when there weren't the same number of cards as people, everyone aboard was told that they didn't present adequate identification and documentation when they came, regardless of whether they had a refugee card with them or not. They were all detained. Thankfully, many of these people have now been released, but some are still in detention, and some of these people had a refugee card are still being detained. Mr. Speaker, I'm going to go back to the idea of an irregular arrival. This concept is not defined in this legislation, but based on the history of this bill, it's easy to jump to the conclusion that irregular arrival means arrival by boat. What this bill is essentially saying is that someone or a group of people who arrive in an irregular fashion or by boat is not a refugee, but rather is a criminal. This bill is saying that people who wish to flee war or conflict or persecution but do not have the means to pay and purchase a plane ticket, so instead they risk their lives, throwing themselves onto a rickety cargo boat and spend months crossing an ocean, are not real refugees. No, Mr. Speaker, they're criminals. That's what this government's saying. They're not real asylum seekers. They're not really fleeing a horrible situation, leaving behind their homes, their livelihood, their families, with the hopes of creating a better life here in Canada. No, these people are criminals. This is what this bill and this is what this government is telling us. Furthermore, if they fail to provide adequate identification, they can be detained without review. Most refugees who come to Canada don't have documentation, regardless of which process is used to enter the country. When people flee their home nation, they leave everything behind. How can we expect people who have left a war-torn country to carry valid identification? And this concept of queue jumping, as the minister likes to say, this is completely bogus. These people still must go through the exact same immigration process as any other immigrant to Canada. Mr. Speaker, when you're fleeing persecution or war, you cannot be called a queue jumper. For refugees, there is no queue to jump. There is no lineup for people who are in serious danger, for people who are living through a civil war, for people who are being persecuted because of their gender, religion, sexual orientation, etc. When your life or the life of your family is called into question, there is no line. These people must leave their country immediately. Once they are safely here in Canada, they must join the exact same queue as everyone else who want to gain some sort of status in our country. The second part of this bill is the part that comprises of C-11 and the calling of safe countries. In the 40th Parliament, after a lot of work and compromise, C-11 passed this House with all party support. It's scheduled to come into effect this spring. However, before the legislation that was passed by this House can even have a chance to come into effect, we have the members opposite, including the original legislation. We have the members opposite, including the original legislation of C-11, excluding any part of the amendments that were accepted by all parties in this current omnibus bill. This government hasn't even given C-11, the original C-11 from last Parliament, a chance to work. Mr. Speaker, I will end with saying that this government is really just using fear-mongering and fear tactics to scare the current immigrants in Canada and current Canadians. They're pitting Canadians against immigrants and newer immigrants against other newer immigrants, and this type of fear tactics is absolutely wrong, Mr. Speaker. Thank you.